USP2 has given a very good stance on this one. I think we heard quite a bit on the settlement type situations in other fact patterns, but here the USP2 encourages settlement also. So the people, the parties to the derivation proceedings can have discussions on how to settle the matter. But the key factor here is USP2 must take action consistent with the agreement. So that's very interesting. So that means the arbitration is very encouraged. So what happens if there is a situation where you didn't have a chance to raise this derivation? You can also wait until the derived patent is granted. So then you can bring in a civil action on that derived patent, and the only owner of a patent may have relief against the owner of another patent, meaning the derived patent. So the other patent claims the same invention. Those are the criteria. Again, the criteria are very similar. The other patent has an earlier effective filing date. The effective filing date has to be after March 16, 2013. The invention claimed in the other patent was derived from the. You have to show all those evidence. Yeah, I think the dates are very important. That's the last bullet there. So now, a little bit on the pre-grant submissions. I think, again, we didn't hear much on this one. It's a very powerful tool, in my opinion, at least. If you find some reference and you think that is material for patentability of whatever that is published, which you are watching out for the competitor patents or whatever that case may be, so you can submit those references to the US Patent Office for consideration. It doesn't mean the examiner, examiner will enter those things. Examiner may not or may use those references while doing the examination, whether that the claim should be rejected based on that reference. You can submit anything like granted patents, published patent applications, or any other relevant publications. If you do submit, you basically have to give a very concise description of any of those references, like the summary or the abstract. Whatever is relevant you think can be highlighted so that the examiner knows what to do with it. And anybody can submit it. It need not be under your name. You can just ask your attorney or their law office to, the law firm to submit those under any name. If you do submit more than 3 references, you have to pay a fee. And this can be done, again, electronically, so it's very easy to do these days. PGR, I think we heard quite a bit on that. I think maybe I'll just touch very briefly. Again, post-grant review is extremely new to the US, again, to harmonize the system with the rest of the world. You can raise any grounds of invalidity when you do the PGR, post-grant review. You can talk about 101, 102, 103, basically patentable subject matter, novelty, obviousness considerations. And also you can raise 112 considerations. That's the indefiniteness, written description, but not best mode enablement. And prior use and offer for sale can be raised in those things. But again, there is a strict timelines here. You have to file it within 9 months. And again, depends on the USPTO whether to grant such PGR. And again, this is something which I really don't know how that is going to be formulated. It can raise any novel or unsettled legal question. I don't know what exactly that means beyond those I listed there. So it really opens up for more than what you can ask for there. And it is conducted by, again, PTAB. Although the last bullet I said may be cost effective, truly it is not that cheap. I think it's in several $1,000s to request a post-grant review. So we have to wait and see how it will be utilized and how USPTO will determine in the future whether to even reduce the fees. Okay, let me run through quickly. I think so. Those are some of the new AIA considerations. And I think, again, when you are creating an IP, it's extremely important. You need to conduct very thorough freedom to operate considerations. I mean, you need to take a look at what you want to patent, which has full freedom to operate. It's extremely important. Otherwise, you may be sitting on some dominant patent, and we'll come to some of those situations. Then you may not have a right to use your own patent, since it is an exclusionary right. So I think that says it all. And the same applies on the infringement analysis, especially if you are really looking at competitor products. So you need to look at various legal doctrines on the infringement, whether it is direct or indirect, and whatever the legal standing of the day, because the laws keep changing. That's the reason I put in the doctrine of equivalence there. So it depends on the situation too, and a lot on the prosecution history. So you need to look at each of those aspects very carefully. And when you are doing all this, you must, I mean, it's good to do your own validity check. I mean, it's good to have a patent which is valid in most jurisdictions. So some patents may be valid in some jurisdiction, may not be in another jurisdiction, depending on your claim drafting. So you need to do those, again, case by case, and make sure you are clean on all the validity analysis. On the invalidation grounds, again, this is just to summarize. I think we heard quite a bit on each one of those, but some of those I just covered. Third-party pre-issuance submissions, post-grant review, some of those are very cheap. And also you can do the ex parte, which is similar to the ex parte re-examination in the past. And IPR, inter parte review, you heard quite a bit on this already. I'm not going to go through any more details on that. And supplemental examination, and needless to say, the litigation is always available outside of the USPTO. The ex parte review, like I said, it's very similar to the old procedures, but and also there is no estoppel, and the only thing you start the process. That's it. If the USPTO starts taking the patent for re-examination, that's it. Your role is done there. On the inter partes review, it can be expensive. On the other hand, I think you heard from some of the earlier speakers. I'm not going to go into more details. But I mean, again, there are pros and cons in it. I mean, there is an estoppel here, and also it is not that cheap compared to ex parte re-examination. This is something you keep in mind. It's very important of all doing all this. At the same time, you need to consider design around. I mean, if there is a dominant patent out there and you have an issue with FTO, you can really make sure how to circumvent that one. I mean, those would be very critical to create such IP. So design around another patent, you can get out of the infringement problem, FTO problems, and you may have your own patent. But there are situations which may arise again where you may want to even block the competitor patents. I think I went too fast there. So that may be another situation where you can design around. You may not have a right to practice your own invention there, your own patent there, but you block the competition too. So this is something to keep in mind. Again, why do we do all this? I mean, especially when you look into the cross-licensing or settlement agreements, it provides a very good leverage for better royalty terms. Or again, you can do this one territorially or product specific. So some of these things are just a remind us, I guess. I mean, especially when the damages, I think it's not dead yet in the USPTO, I mean, in the US system at least. If there is a willful infringement, which is probably difficult to prove these days, it's still the treble damages there. So you have to be very careful. Sometimes the companies just disappear because of that. And again, depends on the way they calculate. If it is just a reasonable royalty, that may be a different situation. Injunctions, which we heard quite a bit on that, and sometimes it's very difficult to get these days. And anyway, the litigation is very uncertain anyway. Well, in conclusion, so you need to really create patenting with many due considerations, and if you do good analysis and obtain strong patents, that would really help your product grow big. And I think that's it. Let me see. Okay, yeah.